We continue with Amendment 60 to Clause 3, with which it will be convenient to debate Amendments 61 and 42 and Government Amendments 92 to 98 to Clause 3. That Clause 3 stand part of the Bill. Amendments 44, 46, 47 and Government Amendments 99 and 100 to Clause 4. That Clause 4 stand part, Government Amendment 101 and Amendment 43 to Clause 5. That Clause 5 stand part, Government Amendments 102 to 105 to Clause 6. That Clauses 6 to 8 stand part, Government Amendments 106 and 107 to Clause 9. That Clause 9 stand part and new Clause 11. Angus Robertson to move Amendment 60.
Cosby, and it's a pleasure to move Amendment 60 in the name of my honourable and right honourable friends, and to speak in this string of amendments and new clauses in relation to elections to the Scottish Parliament and for local government. As members will be aware, the Cross-Party Smith Commission report recommended at paragraph 23 that the Scottish Parliament should have all powers in relation to elections to the Scottish Parliament and local government elections in Scotland, but not in relation to Westminster or European elections. This will include powers in relation to campaign spending limits and periods and party political broadcasts. Additional detail was set out in paragraph 24 of the agreement. In terms of our approach to amending the bill, clauses 3 to 9, the focus of this group of amendments seeks to address this recommendation. While these clauses have some merit, we believe that there are still a number of issues to work through with the UK Government. For example, and in particular, some parts of the clauses limit the Scottish Parliament's powers beyond those proposed in Smith. As the Scottish Government has set out in its response to the report of the Scottish Parliament's Devolution Committee, Clause 3 does not fully implement the Smith Commission recommendation, and that's why the Scottish Government has proposed an alternative to this clause, which forms a basis for our amendments this evening. Our proposal would replace, rather than amend, the Section B3 Elections Reservation in Schedule 5 of the 1998 Scotland Act. This is designed to make the effects of the clause clearer. Under our proposal, Part A reserves elections for membership of the House of Commons and the European Parliament, while Part B refers to Scottish Parliament elections and local government elections in Scotland. Our amendments reserve the holding a Scottish election vote on the same day as a UK parliamentary general election, a European parliamentary election, or an ordinary local government election in Scotland. This puts into place paragraph 24(4) of the Smith report. As the Scottish Government stated in its response to the Devolution Further Powers Committee, and I quote, "We have removed paragraph B of the combination of polls provision in Part B, which would have had the effect of reserving the combination of devolved polls. Should the timing rules be varied to allow ordinary Scottish Parliament and ordinary Scottish local government polls to coincide, then the Secretary of State would have had competence over the devolved conduct rules, which would otherwise both be the responsibility of the Scottish Parliament. This is clearly undesirable and goes beyond the Smith recommendation. The Scottish Government suggested alternative drafting in relation to the digital service, which they and we think is clearer by the actual effect of the reservation. The reference to the reservation of Parts 5 and 6 of the Political Parties, Elections and Referendums Act 2000 is the same as in the Scotland Bill. The Scottish Government has said that it is generally content with clauses 4 to 9, subject to the following changes it is proposing to the UK Government. Again, an area where, see, the Secretary of State is not in his place, but no doubt his colleagues on the Treasury bench will be taking notes avidly to ensure that these suggestions that have been made by the Scottish Government, and we've heard in good faith, these will be taken on board and considered in full, and hopefully they will. The House will excuse me if I rely heavy on the points of detail set out by the Scottish Government and shared with the UK Government and indeed to the Devolution Committee of the Scottish Parliament. The first of those, in relation to Clause 4, the part which enables Scottish ministers to make provision by order for the combination of polls for a specified list of polls that currently may coincide, could be simplified. The reservation of the power to make combination rules could be removed from B3, and the list of coinciding polls at section 12(2)d could be replaced with provision that gives Scottish ministers power to provide for the combination of polls and referendums that are within the legislative competence of the Scottish Parliament. Point 2. The references to use of the digital service could be seen to conflict with Clause 6. This currently gives Scottish ministers some powers to make provision with the agreement of the Secretary of State. This could be read as restricting the use of the digital service beyond what is actually needed or intended. Point 3. In Clause 5, subsection 3, goes beyond what was recommended by the Smith Commission. The Smith Agreement clearly sought only to prevent the polls from being held on the same day. The Scottish Government would wish to adhere to that narrow limitation. Their preference would be for the words "or within 2 months before" to be omitted from subsection 3 of Clause 5. Point 4. In Clause 6, the Scottish Government's view is that the definition of use of the digital service is overcomplicated. They also believe that the inserted section 6.3 may be out of step with existing provision in this area, as it appears to suggest that a person cannot use a digital service unless they are eligible to register, when there is nothing to suggest any current restriction on those who may use the service. If the purpose of the digital service is to determine whether an applicant is eligible to register, then this provision could be omitted. Point 5. Also in Clause 6, and in common with their approach to the vetoes throughout the bill, we believe that the provision at 11, regulations made by Scottish ministers by virtue of subsection 9, may not be made without the agreement of the Secretary of State, should be removed. We will, of course, return to vetoes at a later stage of our considerations. Point 6. In Clause 7, the Scottish Government has noted that this power does not apply where any other poll is combined with a Scottish Parliament election. They accept this in principle as a practical approach, but they suggest that it should be limited to the combination of a Scottish Parliament election with any other poll that is out with the Parliament's competence. The provision as drafted would have the effect that, should the timing provisions be varied to permit Scottish Parliament elections to be combined with local government elections in Scotland, the combination rules would be reserved, which would be undesirable. And point 8. In Clause 9, Scottish Government argues that subsection 6 can be omitted as the Scottish Parliament Elections etc. Order 2010 is already devolved under the Scotland Act 2012. The Smith Commission recommended that the Scottish Parliament should have all powers in relation to Scottish Parliament elections and elections to local government in Scotland. In doing so, the Commission specifically stated that this would include party political broadcasts. There does not appear to be any provision to this effect in the draft clauses. We hope the Government, in particular, will address this point. The Smith Commission also recommended that the Electoral Commission will continue to operate on a UK-wide basis. The Scottish Parliament will have competence over the functions of the Electoral Commission in relation to Scottish Parliament elections and local government elections in Scotland. The Electoral Commission will report to the UK Parliament in relation to UK and European elections and to the Scottish Parliament in relation to Scottish Parliament and local government elections in Scotland. Mr. Chairman, we believe that Clause 3 does not fully deliver the second part of this recommendation. An alternative approach should be considered to give greater clarity and to ensure that the Scottish Parliament will have competence over the Commission's functions in relation to Scottish Parliament elections and local government elections in Scotland. These may seem very technical areas, but they are pretty important. I note that the front bench has been listening with interest and no doubt will look at the record. Hopefully they could be persuaded to accept Amendment 60 later on in proceedings, and should they not, no doubt, I trust that they will be consulting with colleagues about how they can take on the technical improvements which we have outlined and I've spoken in support of this evening.